With deadlines practically here, the Supreme Court has finally dropped the Rahimi decision. This one we've been looking forward to for months to get further clarification on the Second Amendment. Let's see if they did it. Let's talk about it. Hey everybody, welcome back to the channel today. It's just going to be you and me as the attorneys are hard at work analyzing the Rahimi decision that has just dropped today. However, while we're waiting for that analytics, I thought that maybe we could run through a couple of cool things that we see in here and at least get some of this information out. If you're not familiar with the Rahimi decision, we've got a few videos within our playlists. Be sure to go check those out. And also, if you haven't seen the video from earlier this week where we actually discussed what was in front of the Supreme Court, I was talking with Chuck Michelle. Rahimi came up and he kind of gave me what he expected would happen in Rahimi, and it seems like that's sort of playing out there. So go ahead, if you want to pause this video, go check out some of those precursor videos and then come back. That's certainly a good way to go. But before we get into that today, please like, share, and subscribe to these videos. It really helps with the algorithms to get this information and this message out there. Also, before we get into it, let's hear from our sponsor really quick with the Police Credit Union. As the trusted financial partner for 70 years to law enforcement and their families, your membership helps continue the support of law enforcement officers throughout the state. As a member, you'll have access to all member benefits, including checking accounts with ATM fee rebates and no monthly fees, certificates with highly competitive rates, auto loans, home loans, online technology with 24/7 banking convenience, and much more. And don't forget, the credit union is now extending memberships to CRPA members. So join today at www.thepolicecreditunion.org. The link will be in the description below, and continue to discover the benefits of membership while supporting law enforcement officers today. All right, guys, so if you did watch our video from earlier this week, you will have remembered Chuck when we were talking about Rahimi, kind of expecting that Rahimi in his specific appeal would lose, but it would be addressed in a very narrow fashion, while being hopeful that the Supreme Court would do a more overarching clarification of Bruen to help Second Amendment litigation get through the court system nationwide. I think that we saw some of that here. There are a few quotes that I want to pull both from the syllabus of the Rahimi decision and then a quote from the Rahimi decision itself to just kind of show that some of these things are happening. So the first one here, Jacob, if you can pull it up, comes from the syllabus. It reads like this. Under our precedent, the appropriate analysis involves considering whether the challenged regulation is consistent with the principles that underpin the nation's regulatory tradition. When firearm regulations is challenged under the Second Amendment, the government must show that the restriction is consistent with the nation's historical tradition of firearms regulations. A court must ascertain whether a new law is relevantly similar to laws that our tradition is understood to permit, applying faithfully the balance struck by the founding generation to modern circumstances. Why and how the regulation burdens the right are central to this inquiry. As Bruen explained, a challenged regulation does not precisely match its historical precursors, still may be analogous enough to pass constitutional muster. So basically what this is saying to me, and again, guys, we are going to follow this video up with the attorneys as they continue to analyze the decision itself and see how this decision can be applied to California litigation. But for now, the way that this sort of reads to me at the very forefront of this decision is saying, hey, we are going to be addressing the Second Amendment in a more broad spectrum and sort of clarify Bruen. But while we do that, you do need to understand that there are regulations that might not be a perfectly analogous fit that can still apply. And I think we see that here in the second quote where, again, if you remember Chuck saying he didn't have too much faith in Rahimi specifically winning his appeal itself, but it being addressed in a very narrow scope, you can see here, Jacob, why don't you pull this one up? It reads like this. The court's decision in Heller and Bruen did not help Rahimi. while Section 922G8 bars individuals subject to restraining orders from possessing guns in the home, Heller never established a categorical rule that the Constitution prohibits regulations that forbid firearms possession in the home. Indeed, Heller stated that many such prohibitions, like those on the possession of firearms by felons and the mentally ill, are presumptively lawful. And the court's conclusion in Bruin that regulations like the surety law are not a proper historical analog for a broad gun license regime does not mean that they cannot be appropriate analog for a narrow one. This is saying basically that. This law did pass constitutional muster in Rahimi's specific challenge. Therefore, it's going to be applied. But when you go into the decision a little bit more, we see the Supreme Court kind of go further into the Bruin decision and clarify a couple things. I thought this part was really cool, specifically pertaining to Bruin and Heller. Jacob, if you could pull this one up, it reads like this. In Heller, our inquiry into the scope of the right began with constitutional text and history. In Bruin, we directed courts to examine our historical tradition of firearms regulation to help delineate the contours of the right. We explained that if a challenged regulation fits within the tradition, it is lawful under the Second Amendment. We also clarified that when the government regulates arms-bearing conduct, as when the government regulates other constitutional rights, it bears the burden to justify its regulations. Nevertheless, some courts have misunderstood the methodology of our recent Second Amendment cases. These precedents were not meant to suggest a law trapped in amber. As we explained in Heller, for example, the reach of the Second Amendment is not limited only to those arms that were in existence in the founding. Rather, it extends prima facie to all the instruments that constitute bearable arms, even those that were not in existence. By that same logic, the Second Amendment permits more than just those regulations identical to ones that could be found in 1791. Holding otherwise would be as mistaken as applying the protections of the right only to muskets and sabers. But really clarifying the fact that we are holding Heller and Bruin to account when we're talking about these things. While it doesn't necessarily apply to Rahimi's specific appeal, they are trying to clarify some of these things. And I guess we can leave it here. While we weren't able to get Chuck on a video today, I will leave you with CRPA's official statement, and this is from Chuck Michel, giving a little bit more of a broad overview of the decision as a whole. It goes like this. Today, the Supreme Court decided the Rahimi case, holding that the government can temporarily prohibit dangerous individuals from possessing firearms. As we expected, the court's ruling is very narrow. It did not decide whether the government can prohibit broad classes of people from possessing firearms permanently, and it rejected the government's argument that irresponsible people could be prohibited from possessing arms. The court reaffirmed the Bruin methodology in allowing the government to disarm persons subject to restraining orders, but only while the order is in effect. Several California laws that created open-ended prohibitions are now vulnerable to challenge, as are policies limiting CCW access based on claimed irresponsibility or expired restraining orders. The central issue in this case was identifying historical laws and traditions that are sufficiently analogous to a modern law that would allow the law to survive a constitutional challenge. The court reiterated the Bruin test used to make that determination, and this clarification should rein in lower courts that have wrongly accepted any historical laws the government presents when not sufficiently similar. The ruling still leaves open many significant questions that we are hopeful the court will address in several active cases, including bans on semi-automatic rifles and extreme limitations on public carry licenses. The court could rule to accept those cases as early as Monday. And guys, it is our intention to get another video out on Monday or Tuesday next week, doing a little bit of a deeper dive into this case. But you can see from this statement here, actually, you can see a lot of things. I guess going backwards, you can see that there are still questions that remain when it comes to Second Amendment litigation. Rahimi did not answer them all as far as the Supreme Court is concerned. However, what Rahimi did answer leaves several laws in California, some currently going through litigation, some potential litigation in the future. It leaves some of those laws vulnerable to the clarification that we've seen here. We are going to continue and follow along with this. I hope that you guys follow along with us. As always, like, share, and subscribe to this channel. Guys, if you like this kind of content and you want to see see this stuff brought to you as soon as possible, please hit that like, share, and subscribe button. It really helps with the algorithms to get this information out there. We'll check back with you guys soon, and we'll see you on the next one.